Please be seated, everyone. Okay, the record should reflect that we are still outside the presence of the jury. They are due to return shortly for closing arguments. Each of the attorneys has a set of jury instructions in front of them. We're going to make our record about instructions. Let's take the first page, has instructions 1 and 2. Any objection to either one of those from the state? No. From the defense? No, Your Honor. The next page has 3 and 4. Any objection from the state? No, Your Honor. From the defense? No, Your Honor. Instruction number 5. Any objection from the state? No, Your Honor. From the defense? No, Your Honor. Let's take 6, 7, 8, and 9. Take a minute to look at those. Does the state object to any of those? No, Your Honor. Does the defense? No, Your Honor. Instruction number 10, I will say we talked about that informally, and I want to make sure each party has a chance to look at it the way that I've drafted it. Any objection from the state?
Yes, Your Honor. Thank you. May it please the court. The state has just a minor objection, and that has to do with a sentence in the third paragraph that reads, "A reasonable doubt is the kind of doubt that would make a reasonable person hesitate to act." We have filed a brief regarding the instruction we would prefer, which is the stock instruction from prior to 2009, when the change was implemented to include the hesitate to act language. And so what we are asking for is the firmly convinced instruction. And as the court is aware, essentially based on our brief and from Iowa Criminal Practice 2018-19, there's still controversy regarding the language that the court has decided to use. And so we would just ask for the firmly convinced versus what we consider objectionable language, which was the hesitate to act language, and primarily because it conflicts with instruction number 29, where you say do not hesitate, where here you say hesitate. Thank you.
Okay. Mr. Firehelm, let me ask you first of all, the way I have instruction 10 proposed, any objection to that?
No, Your Honor.
Do you want to respond to the state's position?
Your Honor, just briefly, I believe that as the state has indicated, this version has been the stock for a number of years. I know that there was quite a bit of input into the jury instructions committee, and this has been tossed about. And I understand there still continues to be some controversy, but I don't believe that there's a risk of any confusion between this instruction with that hesitate word versus 21 or whatever one that was. So we'd ask that we use the one as in these proposed instructions.
Again, for the record, we talked about this informally. I let the parties understand that my position is the language is not confusing to the jury. Both places do use the word hesitate, but they refer to something different. I think it's the stock instruction that we've been using most recently, and I don't think it causes confusion. I am going to overrule the state's objection to it and allow it to stand the way I've written it. Let's turn on to the next page. 11, 12, 13, and 14. Any objection to any of those from the state?
No objection.
From the defense?
No objection.
15 starts with the marshaling instruction. Let's take 15 and 16. Any objection from the state?
No objection.
From the defense?
No objection.
The next page has 17, 18, 19, and 20. Any objection from the state?
No objection.
From the defense?
No objection.
Then we go into the marshaling instruction for murder in the second degree, instructions 21 and 22. Any objection from the state?
No objection.
From the defense?
No objection.
The next page has 23 and 24, and let's go into 25. Any objection to any of those three from the state?
No objection.
From the defense?
No objection.
26 defines specific intent. Any objection from the state,
No objection.
from the defense?
No objection.
And then I think we can take the last 4. I believe they're all stock instructions. Any objection to any of those from the state,
No objection, Your Honor.
from the defense?
No objection.
Are there any instructions that we have not talked about and I have not included that the state is proposing be included in the set?
No, Your Honor.
Any from the defense?
No, Your Honor.
Okay, I have a proposed verdict form. Has the state seen that?
Your Honor.
Any objection to that?
No objection.
Any objection from the defense?
No, Your Honor.
Okay. Are the parties ready for closing argument?
Yes.
Okay. We've got, the printed sets are on the desk by the copy machine and by Dana. There should be 14 of them. If you want to grab them and then grab the jury, pardon me? They're all ready to go. You can grab those and bring the jury in. Please be seated, everyone. Okay, ladies and gentlemen, as you walked in the courtroom, the court attendant handed each one of you a set of jury instructions. We're going to start reading these instructions now. I will read most of them to you at this point in time. I say most because the last few are procedural and they explain to you what you should do procedurally when you start your deliberations. We'll save those until after the attorneys have finished their closing arguments. The most that I'll read right now, the beginning instructions, are sort of the meat of the law. I'll read these out loud. You can read along with your set. You can put them in your lap and listen, whatever works best for you. Instruction number 1, members of the jury, the trial information charges the defendant, Todd Michael Mullis, with the crime of murder in the first degree. The trial information includes the lesser crimes of murder in the second degree, voluntary manslaughter, and involuntary manslaughter. Instruction number 2, Todd Michael Mullis has entered a plea of not guilty. The plea of not guilty is a complete denial of the charge and places the burden on the state to prove guilt beyond a reasonable doubt. Whenever I instruct you the state must prove something, it must be by evidence beyond a reasonable doubt. If the state does not prove the defendant guilty beyond a reasonable doubt, your verdict must be not guilty. Instruction number 3, the trial information is the document that formally charges the defendant with a crime and is merely the method by which the defendant is brought into court for trial. It is not evidence. Instruction number 4, Todd Michael Mullis is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of the defendant. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. Instruction number 5, you shall base your verdict only upon the evidence and these instructions. Evidence is 1, testimony in person or by deposition. 2, exhibits received by the court. You may examine the exhibits closely, but be careful not to alter or destroy them. 3, stipulations, which are agreements between the attorneys. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes during a trial, references are made to pretrial statements and reports, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to which were not offered and received into evidence are not available to you. The following are not evidence. 1, statements, arguments, questions, and comments by the lawyers. 2, objections and rulings on objections. 3, any testimony I told you to disregard. 4, anything you saw or heard about this case outside the courtroom. Instruction number 6, in considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Instruction number 7, decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence, but if you cannot, accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many factors which you may consider in deciding what testimony to believe. For example, 1, whether the testimony is reasonable and consistent with other evidence you believe. 2, whether a witness has made inconsistent statements. 3, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts. 4, the witness's interest in the trial, their motive, candor, bias, and prejudice. Instruction number 8, you must determine whether the defendant is guilty or not guilty from the evidence and the law in these instructions. You must consider all of the instructions together. No one instruction includes all of the applicable law. Instruction number 9, nothing I have said or done during the trial was intended to give any opinion as to the facts, proof, or what your verdict should be. Instruction number 10, the burden is on the state to prove Todd Michael Mullis guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence in the case or from the lack or failure of evidence produced by the state. A reasonable doubt is a doubt based upon reason and common sense and not the mere possibility of innocence. A reasonable doubt is the kind of doubt that would make a reasonable person hesitate to act. Proof beyond a reasonable doubt, therefore, must be proof of such a convincing character that a reasonable person would not hesitate to rely and act upon it. However, proof beyond a reasonable doubt does not mean proof beyond all possible doubt. If, after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt and you should find the defendant guilty. But if, after a full and fair consideration of all the evidence in the case, or from the lack or failure of evidence produced by the state, you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt and you should find the defendant not guilty. Instruction number 11, if there is a reasonable doubt as to the degree of the crime, the defendant shall only be convicted of the degree for which there is no reasonable doubt. Instruction number 12, the duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. Instruction number 13, where 2 or more alternative theories are presented, or where 2 or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact leads to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which it is based. Instruction number 14, to commit a crime, a person must intend to do an act which is against the law. While it is not necessary that a person knows the act is against the law, it is necessary that the person was aware he was doing the act and he did it voluntarily, not by mistake or accident. You may, but are not required to, conclude a person intends the natural results of his acts. Instruction number 15, the state must prove all of the following elements of murder in the first degree. 1, on or about the 10th day of November 2018, the defendant committed an act upon Amy Mullis. 2, Amy Mullis died as a result of the act of the defendant. 3, the defendant acted with malice aforethought. 4, the defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill Amy Mullis. If the state has proved all of the elements, the defendant is guilty of murder in the first degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the first degree, and you will then consider the charge of murder in the second degree, explained in instruction number 21. Instruction number 16, malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences, as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another which exists before the act is committed. It does not have to exist for any particular length of time. Instruction number 17, willful means intentional or by fixed design or purpose and not accidental. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. Premeditate is to think or ponder upon a matter before acting. Instruction number 18, deliberation and premeditation need not exist for any particular length of time before the act. Instruction number 19, if a person has the opportunity to deliberate and uses a dangerous weapon against another resulting in death, you may, but are not required to, infer that the weapon was used with malice, premeditation, and specific intent to kill. Instruction number 20, a dangerous weapon is any device or instrument designed primarily for use in inflicting death or injury, and when used in its designed manner is capable of inflicting death. It is also any sort of instrument or device which is actually used in such a way as to indicate the user intended to inflict death or serious injury, and when so used is capable of inflicting death. Instruction number 21, the state must prove all of the following elements of murder in the second degree. 1, on or about the 10th day of November 2018, the defendant committed an act upon Amy Mullis. 2, Amy Mullis died as a result of the act of the defendant. 3, the defendant acted with malice aforethought. If the state has proved all of the elements, the defendant is guilty of murder in the second degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the second degree, and you will then consider the charge of voluntary manslaughter, explained in instruction number 23. Instruction number 22, murder in the second degree does not require a specific intent to kill another person. Instruction number 23, the state must prove all of the following elements of voluntary manslaughter. 1, on or about the 10th day of November 2018, the defendant committed an act upon Amy Mullis. 2, Amy Mullis died as a result of the act committed by the defendant. 3, the act was done solely by reason of sudden, violent, and irresistible passion resulting from serious provocation. If the state has proved all of the elements, the defendant is guilty of voluntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of voluntary manslaughter, and you will then consider the charge of involuntary manslaughter, explained in instruction number 25. Instruction number 24, concerning element number 3 of instruction number 23, a serious provocation is conduct that would cause a reasonable person to have a sudden, violent, and irresistible passion. Passion is not sudden, violent, and irresistible if there is an interval of time during which a reasonable person would, under the circumstances, have time to reflect and bring her passion under control and suppress the impulse to kill. Words alone, however abusive or insulting, cannot be serious provocation. Instruction number 25, the state must prove all of the following elements of involuntary manslaughter. 1, on or about the 10th day of November 2018, defendant recklessly committed an act upon Amy Mullis. 2, the defendant did the act in a manner likely to cause death. 3, by doing the act, the defendant unintentionally caused the death of Amy Mullis. If the state has proved all the elements, the defendant is guilty of involuntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty. Instruction number 26. For the defendant to know or have knowledge of something means he had a conscious awareness of it. Specific intent, as used in these instructions, means not only being aware of doing an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining the defendant's specific intent requires you to decide what he was thinking when an act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You may, but are not required to, conclude a person intends the natural results of his acts. Okay, we're going to stop right there. You can leave your instructions open. As I said, we will take the closing arguments. Shelley, do you want to get the court reporter, please?